The Right on Point podcast is a candid discussion of your legal rights, civil liberty ramifications, legalities of possible mandates of COVID vaccines, and actions by our federal government and state governments. Plus exploring the untouchable topics within the National Vaccine Injury Compensation Program, the PrEP Act, and the Countermeasures Injury Compensation Program. Welcome to the Right on Point podcast with Wayne Rohde.
Welcome back, everyone, and thank you for being here on the Right on Point podcast. I'm your host, Wayne Rohde. Some of you have been very aware of some court decisions in the last couple of weeks and legal proceedings, breaking news, even on congressional hearings. As it moves through the vaccine safety, the health freedom communities, it moves very fast, the speed of light. And recently, the U.S. Court of Appeals for the Ninth Circuit issued a ruling from a lawsuit challenging the Los Angeles United School District's COVID-19 vaccine mandate. And social media accounts blew up everybody's computer and phone, mine included. And it was quite interesting, but at the beginning, there was a lot of misinterpretations of the court's ruling. I was out there trying to tell people just to kind of slow down. Let's get a better grip. It's not just about, the COVID vaccine is not a vaccine or whatever, but the pleadings of this case is what's really interesting. So I wanted to get someone who is at the heart of this lawsuit. So I reached out to Leslie Manookin from Health Freedom Defense Fund, one of the named plaintiffs in the lawsuit against the superintendent of Los Angeles United School District. Is it Alberto Carvalho?
Carvalho, yeah.
Carvalho. So it's an interesting case. Some of the listeners might remember my guest, Leslie Manookin, from the Greater Good movie that was released, I think it was maybe 12, 13 years ago.
2011.
It's been around. And it was one of the first movies that I watched in regards to health freedom and vaccine safety and the vaccine injury community. And it's still on my player, ready to go at a moment's notice. I still have a copy of it. So Leslie, you had a busy weekend about a week and a half ago at a legal conference in Denver when the news broke. And thank you very much for taking the time to come here on our program and talk about this case. Now, kind of in a summation, can you talk about what was actually the interpretation, or what did the ruling from the Ninth Circuit actually create? What's the nuts and bolts of this decision?
Can I give a little background first, Wayne, because it's really important for people to understand the context, because it didn't happen in a vacuum. So because of the fact that I had made the greater good and been researching vaccines for 20 years, when 2020 unfolded, I knew what was going on, which is that they were going to use this new virus out of China as a excuse for a really authoritarian response in the name of public health. I was certain of it from the early days of January, and I even said it to my husband, and he laughed and he said, "Oh, honey, don't be serious." But if you look at what different legislation they've put in place over the last 20 years, and understand that they were paving the way for the authoritarian response, going back to 2 weeks after the Patriot Act, and then 2 weeks after the implementation or the introduction of the Model State Emergency Health Powers Act legislation, which accorded extraordinary powers to governors and health departments, state health departments, in the event of a public health emergency. So it was just all the pieces were put in place. But what happened was, so early 2020 unfolds, and I am thinking, well, the big one is finally here. I got to do something about this. And I had just had the great fortune of meeting some fantastic attorneys, trial lawyers, very experienced international commercial litigators. And I thought, they need to know, they need to understand what's going on in this. and then help us kick some butt in the federal court system. And so I started explaining all the problems with the vaccine court, with the National Childhood Vaccine Injury Act, with the compensation program, everything, no due process, no discovery, and all this stuff. And we started doing a lot of research anticipating that mandates were coming. And so when the mandates started to begin, and the Los Angeles Unified School District was the first school district, it's the second biggest in the United States, and it was the first school district in the country to shut down. So we were anticipating that they were going to issue a mandate, especially because the superintendent of schools was telling everybody in the media, we're going to mandate the shot for all employees and all students. So I started to hear from teachers, oh my gosh, what am I going to do? Please help, please help. And then one woman, Vanessa Vance, she reached out to me, having gotten my information from Michael Kane of Teachers, New York Teachers for Choice. And we started talking, and then we decided we were going to challenge the emergency use authorized mandate. So basically, LAUSD in March of 2021 followed through with all of their warnings for months in advance of that and issued a mandate of the EUA shot. Now, that's a violation of federal law. EUA products, any kind of EUA, emergency use authorized medical countermeasure, carries with it the right to refuse or accept. You don't have to use it. You do not have to. It cannot be mandated. And so that's what we argued. So we filed suit in March of 2021. And the following day, the Los Angeles Unified School District, LAUSD, rescinded their mandate and said, it wasn't really a mandate. It was just a recommendation. We didn't really mean it. You can just test instead. You don't have to take the shot. And so that case worked its way through the court. And then in July 27th of 2021, so the same year, just a few months later, the district court dismissed our case without prejudice, arguing that there was no longer a ripe issue to be adjudicated. So they dismissed the case and said, listen, it doesn't seem like they're going to issue a mandate. They're saying there's no mandate. They're saying they're not going to issue a mandate. LAUSD said that any speculation or any talk of a future mandate is pure speculation. The case is moot. And so the case was dismissed by the judge. 17 days later, LAUSD issued a mandate for the shot. 17 days after they convinced the judge that they weren't going to do it, they did it. So, I mean, this is pretty obnoxious. Talk about audacious for the school district to do something like this. And the reason I think it's so important for people to understand is because it's come back to bite them on the rumps. So 17 days later, they rescind. All of these plaintiffs and employees who we were helping say, what are we going to do? LAUSD fires 500 people, and then they start pushing more employees into early retirement. They displace them, just say, you have to go on unpaid leave in 2 months if you don't get the shot. You can apply to go in our online academy. And so I think about 100 people made it into the online academy. So they were remote, but they were treated like pariah and told, you are not allowed to come on campus. Do not set foot on campus. So it's just horrible what happened to them. They lost their seniority. They lost their pensions. They lost so much medical care or coverage, all of this stuff. So we file again in November of 2021. And we weren't a plaintiff. Health Freedom Defense Fund, the organization that I lead and that I founded to start fighting back, was not a plaintiff in the first case, but was a plaintiff in the second case. But we were the ones behind the whole scene. It was our attorneys who were managing the whole case and who coordinated the first one. So we were just not a plaintiff yet, but we were a plaintiff in the second case. And along with California Educators for Medical Freedom and several named plaintiffs. Now, this case was slightly different. We decided we weren't going to go after the EUA. What we wanted to do was go after the shot itself and say that Jacobson doesn't apply. Jacobson is the Supreme Court case from 1905 that all the school districts and all the state entities and everybody was using to justify mandates. And we said, that's wrong. Jacobson doesn't apply here because the shots don't stop transmission or infection. A fact we knew in July, actually, I think it was the end of July of 2021, when the CDC issued new guidance saying that vaccinated and unvaccinated individuals should not be treated disparately. So we refiled and we argued in this second case that the COVID shots do not stop transmission or infection. We argued that natural immunity is superior and must be recognized by the courts. We argued that Jacobson does not apply because the shots don't stop transmission infection and because Jacobson applied to an extreme situation, which was a smallpox outbreak with a 30 to 40% death rate. And that is not what COVID was, right? We knew from the Princess cruise ships that this had a death rate very similar to the seasonal flu. And we also said that Jacobson is at odds, in conflict with more recent jurisprudence, such as Cruzan versus Director of Missouri and Washington versus Glucksberg, which are just two of the cases that we noted. But these two cases are very important because they went to the Supreme Court, and the Supreme Court determined in those cases that Americans have a liberty interest, a fundamental right to refuse unwanted medical interventions that are purely for their own benefit, even if they could save their lives. So this is really important. And this is perhaps the most important aspect of the case, is that we said, listen, Jacobson doesn't apply to a medical intervention. It doesn't. And it was the first, we were trying to get the courts to update Jacobson to recognize that unless a medical intervention, a vaccination, stops transmission and infection, then it actually doesn't fall under the purview of Jacobson. And this is why the case was so important, because the Ninth Circuit ruled that what we pled must be accepted as true. They asked the questions in oral argument last year. Do the shots stop transmission? Everybody knows they don't stop transmission and infection. And so what's your argument? And the Los Angeles Unified School District attorney, Connie Michaels, just kept saying, the court needs to give us the right to decide. The court needs to give the state the right to decide, even if it doesn't do anything. So that's the kind of background. The other thing I want to say about it is that's very, very important is that we filed in November, and then in September of so we filed in November of 2021. In September of 2022, our second case was dismissed by the court, and the court said it doesn't. That the case is dismissed because of Jacobson. This is why it's so critically important, because Jacobson, the court said, applies here and means that the state has the right to mandate a vaccination. And the problem is, just because CDC calls it a vaccination doesn't mean it is one in the traditional sense or in the Jacobson sense. So the court dismissed the case. But before the case was dismissed, we had gotten to do depositions. And during deposition, we learned from a senior official in HR, Ileana Davalos, that she had been instructed to draft a mandate in early July of 2021. That is the exact same time that LAUSD was arguing to the court that they didn't have a mandate and weren't intending to issue a mandate. So they were misrepresenting what was going on behind the scenes. And this is a major problem. They were basically manipulating the jurisdiction of the court. And the Ninth Circuit didn't like that very much. So we found this out through deposing these officials before the case was dismissed in September. And then, to add insult to injury, LAUSD went after us for fees, $209,000 of attorney's fees, claiming that our case was frivolous, and they tried to have the court sanction our attorneys as though they knew that it was a frivolous case and pursued it anyway. I mean, it was just outrageous, appalling. We filed our notice of appeal, and then we filed the appeal in January of 2023. We ultimately won. The district court ruled against the Los Angeles Unified School District, and literally in one sentence just said, for reasons noted by plaintiffs, fees denied. So she just smacked them down, LAUSD, when they went after us. But then what happened was, in September of 2023, we went before the Ninth Circuit Court of Appeals, and the Ninth Circuit heard oral argument in the case. And so what happened here is that Connie Michaels, the lead counsel for LAUSD, appears, and so did our attorney and us, one of our attorneys, John Howard, who's the head of the J.W. Howard law firm. And so he came and he conducted oral argument for us. And during oral argument, the bench really eviscerated the Los Angeles Unified School District attorney, Connie Michaels. They said, wait, it has to work, right? And they said, wait, so this policy that you have in place from March of 2021, if somebody got 2 shots back in March of 2021, they're compliant. But a new hire today in September of 2023 is not compliant unless they've had 2 doses right now. Yes, that's correct. But that's ridiculous. That's irrational. That's what the judges said. That's irrational. One of the judges said, I just can't believe this. I'm just floored. I am just shocked. So they expressed a lot of concern, and they were quite dubious of the fact that LAUSD still had this policy in place and that they really couldn't defend it. And all they could say is CDC says they're safe and effective. That was all they could say. And so after oral argument, where they really got a lashing, as our attorney John and Connie Michaels were exiting the bar, Connie Michaels turned to our attorney and said, "What are you going to do when they rescind the mandate?" And she clearly lost her cool. I think she was just stunned by what had just happened because she was so vigorously questioned by the judges. But so she lost her cool, and that's what she said. And that afternoon, so oral argument, I don't know, it concluded somewhere around noon, maybe a little bit thereafter. That very afternoon, the superintendent of schools messaged the school board and said, I think we should rescind the mandate. 12 days later, the school board rescinded the mandate. And what's really interesting is that the Ninth Circuit mentioned all of these facts in their ruling, saying this case is not moot. They actually stated that the court was not mooted. I'm going to read this to you. The case was not mooted by LAUSD's rescission of the mandate after oral argument last September. They called out LAUSD's gamemanship for what it was. We said that it was a bald-faced attempt at avoiding an adverse ruling by trying to create an issue of mootness. But what the actual court said was that LAUSD appears to have twice sought to manipulate the federal courts to avoid an adverse ruling on this issue. And they also, the other piece of it that was so important. So first of all, they denied the motion of mootness. They said that was wrong, that the court was wrong to dismiss this as moot, and we are not going to fall for it because it's clear that the school district has been manipulating us. They implemented and then rescinded a mandate twice due to perceived adverse litigation risk. And that is the very textbook. I'm sure you know this, Wayne. That's the textbook definition of voluntary cessation, right? If someone stops doing something illegal in order to evade judicial review, that is not grounds for the court to not actually adjudicate the issue. And so the courts, I believe, very rightly found in our favor because LAUSD had been playing games, basically, very cynically playing games. And then the other huge thing, I know I'm going on, but it's a long.
Go for it. This is
the other big thing is that what the court said is that the district court thus erred in holding that Jacobson extends beyond its public health rationale. Government's power to mandate prophylactic measures aimed at preventing the recipient from spreading disease to others to also govern forced medical treatment for the recipient's benefit. They said the court erred in applying Jacobson, that it was misapplied because Jacobson does not involve a claim in which the compelled vaccine was designed to reduce symptoms in the infected recipient rather than to prevent transmission. So when Jacobson was determined in 1905, the court assumed that the shot stopped transmission and infection and therefore had a public health justification. Not the case with the COVID shot. So this is monumental because it's the first time that a court has actually narrowed the application of Jacobson and said, all these times for all these years that it's being used to justify every mandate you can imagine, that's not acceptable. That's not going to fly anymore.
There was a video, though, actually it's out on Rumble, maybe on YouTube, but YouTube might have taken it down, of the oral argument and of a couple of the justices questioning the attorney for the Los Angeles Unified School District. And it's unbelievable the responses that she gave back to the justices. Now I'm going to link that up for the viewers of the show so they can follow along. But I found it very fascinating that these justices saw through the smoke and mirrors of what the school district was trying to move forward. Now, my
Well,
question,
Wayne, one thing we
yeah,
did file something called a notice of judicial review, I think is what it's called. We basically notified the court of what LAUSD had done. So we just said, hey, court, that was kind of amazing what just happened in oral argument. And just so you know, the Los Angeles Unified School District just rescinded their mandate. And it seems to us like that was in response to the very harsh the very, let's just say, contentious oral argument that they just endured. And evidently the court agreed with us, because then they ordered LAUSD to then brief the court on mootness and why the case was not moot, or why the voluntary cessation doctrine didn't apply.
I
Same,
just,
and then they asked us. So I mean, I think it was a very shrewd move on the part of our attorneys to file that notice, because it was important for them to understand. And it was also very shrewd for one of our other attorneys to point out that we needed to put in all of the background about what LAUSD had done in the first case, because it established a pattern of behavior.
I've heard of John Howard before. I've never had the pleasure of talking with him, but pretty astute attorney. And when I've talked to some other folks just casually about this topic, I mentioned John Howard, they're all just going, their attention just jumps up. This guy is, the right man for the job, or the right person for the job, excuse me. Now, the next steps here, they've got what, another week or so before a deadline to file if they want to do an en banc type
Yeah.
hearing, I
Let me
believe.
just say, I want to take my hat off to Scott Street as well, who has, he wrote the appeal, and to another attorney of ours, Bran Hadaway, who wrote the original complaint and constructed all the arguments. They both did a fantastic job, and Scott does a bunch of work for us, other cases. We just won a big case against Disney. We won a settlement against Disney, and Scott led that whole case, and he's leading our cases against Nike as well, which we very much hope go to trial. So those are other really important things. And, John is the leader of the firm, but they all have played an instrumental role. And so I don't want to take anything away from those guys. And so what happens now, Wayne?
We'll get into some of those other cases here shortly, because people need to know about your organization and everything that you're doing. But let's get back to the what I call the next steps.
Yeah.
We're either going to have an en banc hearing, which I don't believe we're going to have one, since the school district was pretty embarrassed by what their appearance and what happened with the original circuit ruling. But then it's going to go back to the district court, correct? Is that where it's going to head back?
So what happened was the ruling that we received, the Ninth Circuit
Right.
issued its ruling 2 Fridays ago and said reversed and remanded. So they reversed the lower court, the district court's ruling, which dismissed our case and said that Jacobson had been misapplied and that the court erred in not construing all that we had alleged as true, because that's what the court's responsible for doing at that stage of the pleadings. And so the court reversed, and then remanded means sends it back to the district court. Okay. So there are 3 options really at this point. One is that we go back to the district court. We just see LAUSD in court, and we now have the opportunity to do what we wanted to do all along, which is to prove our case in court that I already enumerated for you, right? That the shots don't stop transmission or infection, natural immunity must be recognized, Jacobson doesn't apply, etc. So we would get the opportunity to pursue that, to prove our case in court. And I feel very confident about that possibility, because there is a mountain of evidence about this. And I think that the defendants will have a very, very hard time proving that this shot actually does anything beneficial. So that's one possibility. And the next possibility is that they can appeal, or they petition rather, to the Ninth Circuit for what's called an en banc review. So when you file an appeal of a district court ruling, you file the appeal to the circuit court. The way that it works in our country is that I'm just talking about the federal court system. The state court system is totally separate, but at the very top is the Supreme Court. Below the Supreme Court, there are all of the circuit courts, the appellate courts, and there are 13 of those in the United States, including the DC court. Idaho is in the ninth, California is in the ninth. So like most of the Western United States is in the Ninth Circuit Court of Appeals, which is where our case was heard because it was filed in the Middle District of California. So we filed in the district court, we appeal to the circuit court, to the Ninth Circuit. And what happens is there are 29 judges who sit on the Ninth Circuit. Other circuits have fewer judges. I think in Florida, it's in the Southeast, it's only 15 judges, something like that, 14 judges. But what happens is when you file your appeal, you get a random draw of 3 judges as your first panel. So that's what we had. We had 3 judges as our first panel. And they are the ones who issued this ruling. What happens next is that, as I mentioned, LAUSD could petition the court for an en banc review, meaning a broader panel of the Ninth Circuit. So what they would ask for is for 9 judges to review the ruling of the 3 judges. So there are 29, they need 15 of the 29 active judges to actually agree to an en banc review. So it's not an easy thing to get an en banc review. And it definitely has real risk for them to do that, but so does going to the district court. So, I mean, it's very, very, it's anybody's guess what could happen. And then the third thing is that they could petition the Supreme Court for review, but I don't think that's very likely. I think that they are likely to have to be reticent to do that. So those are really what we see as the main options at this point. And it's many people have said to us, Wayne, that, I can't believe this came from the Ninth Circuit. I can't believe you got this ruling in the Ninth Circuit. But the reality is the Ninth Circuit is actually a really good place to be on this case, because the Ninth Circuit has led the country in medical privacy case law and bodily autonomy case law, because they are doing all they can to protect unfettered access to abortion. So how do you, on the one hand, say you get the right to bodily autonomy for these things, but not for those things? So the Ninth Circuit is faced with a bit of a conundrum, I think, here. If they overturn this, it's going to be very, very interesting. And it sets up a Supreme Court appeal for sure, if that's what happens.
Or later, you'll be making your way probably to DC sooner or later. Hopefully, well, we'll see. Maybe.
We'll see. I mean, I would love it if we could just go to the district court and prove our case. It would be fantastic. And we could then, we could depose more officials. We could actually conduct discovery, get all of their emails and go through them all. I mean, that would be quite interesting. And I might even say fun.
Okay. Well, we've got a few more minutes here. I want to kind of switch gears. Let's talk about your group, because Health Freedom Defense Fund, maybe to many, was not widely known as Children's Health Defense and ICANN and all this, but you're the one that's actually doing a lot of the work. And on the legal point of view, if you go out to the website, you can see a lot of different cases that you're working on. Briefly, here's a question, a personal question from me to you is, you go from Wall Street to this. And I worked in the brokerage business years ago. And geez, I'll date myself, it's the late 80s. And working for Peter Lynch up at Fidelity and all this stuff like this. So I understood that. And you came from the Goldman Sachs world and a few other places. But then why Health Freedom Defense Fund? Because you started out with a movie, what, 12, 13 years ago, The Greater Good. And what led you to what you're doing now? That's interesting.
So, I had no idea that vaccines had a downside. It never occurred to me that there was any potential negative impact of a shot. I thought they were pure upside. They were the greatest invention of mankind. That's what I believed. I got every shot that I was ever told to get up until a certain point in my life when I realized I started doing research and thought, but I was getting flu shots into my 30s. When I was 28 and graduated from business school, before I went and started my job at Goldman, I went and got every shot they would give me at the University Medical Center. And my health has never been the same, Wayne, but I never connected the dots until the middle of making the movie. So what happened was I was really sick and didn't know why I was sick. And I kept going to the doctor. I'm living in London, working at Goldman. I am just sick all the time. And my health had just gotten worse and worse after those shots. And my doctor said, I know you're sick. You know you're sick. Why don't you? But I can't help you. He said, I don't think Western medicine can help you. I think you need to go and see an acupuncturist or a homeopath. And homeopathy is very big in England, where I was living. I was living in London. And so I asked around for a good homeopath and waited for 3 months to get in to see this woman. And it was really life-changing, so much so that I enrolled in homeopathy college 6 months later. And the very first day in homeopathy school, the person leading orientation said, over the next 3 years, we're going to talk about all of these different issues. We're going to learn about all these topics. We're going to learn about the mind-body connection. We're going to learn about nutritional issues and organ systems. We're going to learn about vaccine damage. I raised my hand and said, what are you talking about? Vaccines are the greatest invention of mankind. That's crazy. And he just shrugged his shoulders and sort of smirked and said, yeah, that's one perspective and we're going to learn another. And I thought to myself, what a nut job. This guy's crazy. Like, oh my gosh. I just thought, okay, whatever. But after the class, he suggested I read a book called Vaccines, Are They Really Safe and Effective? And so I did that. And that book by Neil Z. Miller blew my mind. It was the first book I read about this stuff. And being an analyst geek by nature, that's what I did. I was a portfolio manager, an analyst, a research salesperson. This is the kind of stuff that I did. I opened the book and there were over 950 footnotes in the back of the book documenting autoimmune conditions, anaphylaxis, seizures, all sorts of neurological developments and disabilities like autism and death after vaccines. It was all there. It was there in the medical literature and in the newspapers going back 100 years. And I just thought, this can't be true. This can't be real. And so I literally vowed that one day, I felt called by God that one day I would make a movie on the subject. And so I stayed on Wall Street for a couple more years until shortly after my son was born. And then I quit because I just wanted to be a mother. I wanted to be the best mother I could possibly be to him. And I didn't feel that I could do that if I had a, nanny and a cook and all these other things. And I was living this life where I was just traveling all the time. And it was too important to me. So I walked away. And I'd also seen a lot of stuff that really didn't sit well with me that I won't go into now, but I'd seen a lot of unethical behavior. I heard the CEO of one of the biggest pharmaceutical companies in the world say that they were going to have to put a black box warning on their packaging because their new drug, their blockbuster drug, was going to kill some people, but they still would do 7 billion in peak sales. And I was just astounded, aghast at this. And I felt I couldn't be. So after my son was born and I felt so pulled by him, it was actually not a very hard decision to make in the end. I left kind of at the top of my career, but so be it. And what happened was then I started doing research for years and years. And in the middle of making the movie, I met all of these people. I live in a beautiful ski resort where there's a lot of affluence, to be very honest. And my filmmaking partners and I thought it would be no problem whatsoever to raise funds to make the movie here. It's a very liberal, kind of progressive oriented kind of a community. We thought that these were people who were going to want to expose wrongdoing by government and stand up for individual rights and freedoms. We thought that it would be easy once we started telling them what was going on. And we did some early screenings of our rough cut, and they just sat there stone-faced, literally unmoved by what we were showing them and all of the research we were showing them and the truth. And we were just shocked by it. And then we started showing this to some conservatives. We had some connections with conservatives, and they would say, well, Of course, the government can't be trusted. Of course, CDC's lying. Of course, they're corrupt. And I mean, we were just really shocked. And so it really started to change my worldview. And over the next, that was probably in 2007 or 8, over the next 12 years, my worldview seriously evolved to the point where at the early part of 2020, I was fully aware that both sides of the aisle are part of the problem, in my view, that they're in on the game, that they're all taking money from the pharmaceutical industry and all the other big businesses, and that they are literally selling out average Americans to the highest bidder. And I was disgusted by it. And I was expecting as well. I'd done all this research, so I knew about, like I said, Model State Emergency Health Powers Act legislation in 2001. And then I knew about the Patriot Act in 2005, which then introduced a liability shield for any manufacturer of a medical countermeasure. And then people don't know this, but the National Defense Authorization Acts of 2011 and 12 rescinded habeas corpus, meaning that Americans can be held without the ability to appeal to a judge against wrongful imprisonment. We can be held indefinitely as long as they deem us an enemy combatant. This is insane, right? And then they started doing other things. So they in 2012, I think, they rescinded the prohibition, the Smith-Mundt Act, on propagandizing American citizens. And in 2016, they set up the program and funded it. So with all of this knowledge of what's going on, that they've actually been paving the way to allow the federal government to lie to the American people, essentially use different programs to propagandize Americans. I was very alert to the possibility of what was going on in 2020 at the very beginning. And I just thought, you know, I've got to do something. And I'd met these fantastic attorneys. And so, I mean, I started planning to set up Health Freedom Defense Fund in the spring of 2020 because I wanted to hit the ground running, and I was expecting them to issue mandates right away. And, you know, listen, there are a lot of great attorneys who've been working in this field for a long time, but we hadn't had a lot of success yet. And I thought maybe we need some sort of really accomplished commercial litigators to weigh in here. Maybe that was wrong. I don't know, but I would say that they have served us very well. So I founded Health Freedom Defense Fund in August of 2020. That was when it was formally stood up as a corporation. We got our 501c3 status, and we filed our first case in March of 2021. So we did all the research, and we already had people coming to us in February of 2021 asking for help. And one of the first groups that came to us was the California educators, all the people, the employees at the Los Angeles Unified School District. And so that's where we started. And so it was just this huge evolution. You know, for me, when I had started to learn about the vaccine issues when my son was born, being in homeopathy school, and I was terrified, but we decided we were going to not do any vaccines right away. As the years unfolded, I realized that that was the greatest decision that we ever made. We never ever gave him a single shot. And doing all of this, starting to realize how medicine had been weaponized against us, I became a homeopath. I started to see that medicine, actually, modern medicine, has it's very, very useful in emergencies and in certain situations, but it's not very useful in chronic conditions and most of the things that ail us today. And I felt like I just did all this research, realizing that the medical complex has a stranglehold on this country in particular, and that it was so important for us to have medical freedom. So when I started to realize that all of these politicians are taking money almost from the medical complex, that you know, I moved home from London and I started seeing ads on television, right? From the pharmaceutical industry. Those were banned before I moved away. And it was just very clear that we had a major problem. And I, through the process of making the film and meeting thousands and thousands of parents of children parents of kids who were injured by vaccinations, I just knew I had to do something. And I started to truly appreciate not just the importance, but the imperative of medical freedom. And that was why I started Health Freedom Defense Fund, because I knew that COVID was the first, challenge that we were going to have to face and tackle. But ultimately, my goal was to establish in the social, the social fabric as a cultural norm, the concept of bodily autonomy, of medical freedom for all, and then to codify that in law. And we weren't going to get there overnight. And so that the second case for Los Angeles Unified School District was the first step at trying to undo Jacobson, to basically narrow it and to get it to get the state to stop using it as this blunt tool to bludgeon people with. So to get the court to say, no, actually, it doesn't apply anywhere. And in so doing, to actually move the ball down the field towards ultimately overturning it. Wayne, this case was decided in 1905. Now, in 1905, I couldn't vote. In 1905, we still had Jim Crow laws in place. In that early part of the 20th century, in a case called Buck v. Bell, the Supreme Court ruled that it had the power and the authority to sterilize a young woman that they deemed to be too unintelligent to have children. This is an era that I don't think any of us want to revisit in any way, shape, or form. And yet we're allowing this lawsuit from 1905 to still dictate what happens today. It needs to be overturned. It needs to be chucked in the garbage. But we're not going to achieve that overnight. We need to actually shift the culture. They say that politics is downstream from culture. Well, so are the courts, so are judges. And I think that this case is the first, this case in front of the Ninth Circuit is the first case that's really been able to break through that kind of cement wall that's been in place for 119 years. And so, that's what Health Freedom Defense Fund is all about and why we're doing what we're doing. And you mentioned some of our other lawsuits. Would you like me to just touch on those real quickly?
Briefly, because we're going to put up we've just put up your website, healthfreedomdefensefund.org. And
Super.
I want you to, if you go down to the bottom, viewers, you'll see a lot of these. But Leslie, just briefly, because this is amazing what you've done here.
So first of all, let me just say, if you recall, on April 18th of 2022, a federal court in Florida issued a ruling vacating the federal travel mask mandate. So CDC had implemented a rule mandating that anybody traveling on an airplane, a bus, or a train, or in one of the hubs, that they all had to force us to wear a mask, even if we weren't sick or even suspected of being sick or anything like that. And even though there's no science showing that they actually do what they are purported to do. So that was us. Health Freedom Defense Fund was the organization behind that. And our attorney, Brant Hadaway, is the attorney who wrote that case. And it was his very, very first case involving the Administrative Procedures Act. And he did just a phenomenal job on that. It was just beautifully written and argued, and he was right, and the court agreed with us. So we're the group that overturned the federal travel mask mandate. So that was the first time that we sued, I think, the Biden administration. But we sued the Biden administration 2 other times, and those 2 other cases were dismissed, not because we lost, because the other courts agreed that we had, with our arguments, but they were dismissed as moot when the Biden administration rescinded the emergency in the spring of 2023, stating that the emergency was over, and then DOJ argued that all of these cases were moot. So those 2 cases, those were fantastic cases. We actually won. We beat the University of Chicago, my alma mater. That's where I got my MBA. They were forcing teachers, so professors and staff members and students, everybody to get the shot. And they were refusing religious exemptions. They were refusing exemptions. And so we filed and we said, this is illegal. And we told, instantly the university responded to us and said, let's work this out. Anyway, we secured religious exemptions to the shots for dozens and dozens of people at the University of Chicago. We just had a big win against Disney, where a case in which they had mandated the COVID shot for their employees, and several of their employees, or I think many of their employees, claimed mandates, but this one was denied. She had a medical exemption for a immune condition, and she had a religious exemption as well because she's a Christian and she believed it violated the sanctity of her body. And they refused her. And they refused her and said that they couldn't accommodate her. She was a receptionist. She was already working from home. She worked for, I think it's called American Dad and American Family and Family Guy, or I'm forgetting the two. She worked for 20th Century Animation, but this case was huge because they were going to have a very, very public airing of their dirty laundry, exposing that this place that claims that they're visionary and, the most wonderful place in the world, that they are actually pretty horrible in how they treat their people, and that they trampled their rights and treated them like they were disposable, all in deference to some executive who didn't want people around him that weren't vaccinated. So that's a recent win. And then, we've had several others, but those are the big ones for now. And then of course this Ninth Circuit is really important. Many people say that the Ninth Circuit is even bigger than the mask case was, because that ruling is now controlling law in the entire Ninth Circuit. So all these other cases that are in progress right now are going to file amendments referencing the Ninth Circuit ruling.
That was one of the things that Warner Mendenhall mentioned too in a conversation I had with him last week. He said that's why it's so important for everyone to follow this Ninth Circuit decision. It's not over, but it really sets you're a table setter, if you will, for hopefully beating back this tyranny, the tyrannical actions of not only our federal government, but our state governments and local jurisdictions. And that's one thing I've noticed about your organization. You're not only got a few federal actions, but you've got some state actions here too, whereas some other groups kind of go after the federal, trying to get, the PrEP Act reversed and all that. And that's just, that's going to be extremely difficult and take for our fetch. You're actually getting some things done, some accomplishments. So people can sign up on your website for a newsletter and make donations and all that, as I believe. And I encourage everybody to do so. Take a look, because your group is actually getting things done. Whereas some others were still, treading water or whatever, and they're taking on some difficult topics, but you're going after some jurisdictions that have incorrectly, over their overreach of people's liberty and health freedom. So thank you very much for all that.
Well, thank you, Wayne. We have a couple of cases against Nike, which I hope are going to go to trial. We've already survived the motions for dismissal, the motions to dismiss those cases. And those are going to be very, very interesting to follow as well. And I believe we'll send a warning shot to all of corporate America, just like the Disney case did, that you can't just disregard your employees' rights. That their rights are their rights and they must be respected. But we're also considering some other cases, taking on some other very interesting cases. One of them is against the Federal Trade Commission for having shut down all of these doctors and naturopaths during COVID, preventing them from actually speaking out. That's just one of them that we might consider. We've got a CPS case where CPS took 4 children wrongly, we believe, and then vaccinated them wrongly against the parents' express wishes and their religious exemption. And one of the children ended up in a coma for a couple of months and now has catastrophic brain injuries. And so these are the kinds of things that we're pursuing. We try to make sure. So let me just say, our objective, I think I mentioned this earlier, is to establish bodily autonomy, medical freedom as a norm in our society, and to codify that in law. And so all the cases that we take on further that goal. They're all designed to somehow chip away, to basically shift the public consciousness and to move the legal ball down the field so that we get to a point where we are each truly free. Because in my opinion, no other person other than myself or my parents, if I'm a child, has the right to tell me what I must put into my body or do with my body. Because if they do, then I'm not free. I don't live in a free country. I'm a piece of cattle. I'm a chattel. That's all I am. I'm owned. I can't think of anything more fundamental. And we know under common law that it's considered a battery to be forced to take a medical intervention against our will. So why are we still allowing this to happen? And ultimately, what we truly hope is that we can overturn Jacobson. And that's what we seek to do over the coming years. So anybody who wants to, support our mission, we are super grateful. Please share our work. You can sign up for our newsletter for free, and we don't bombard you. It's not every day. It's once every, usually 10 days to 2 weeks. Every now and then, if we've got something late breaking, we may send it out more than that, but it's usually twice a month, roughly. And then you can become a member for $10. You can donate at our website as well. It's healthfreedomdefense.org. And we can't do this work without the support of, all of your viewers and people like them who care about these really, truly fundamental rights.
Wonderful, wonderful. Well, we're out of time. I know you got to run, so you've been a busy schedule, but you've been watching and listening to the Right on Point podcast, everyone, a candid discussion of your civil liberties and your legal rights with your government. We discuss what no one else will by digging deep into the PrEP Act, the vaccine injury compensation programs, the corruption of our federal government and agencies, the legalities of the COVID pandemic, and what is happening in our global community. I want to thank my guest today, and I really, really appreciate your time. I know it's valuable, and you've got a busy schedule. Leslie Manookin, once again here with the Health Freedom Defense Fund. Ben Smith is my video editor with Backwoods Media, and he's going to have a little bit of work to do here. Ben, I stumbled over a couple words, but we got some things we'll get done. Thank you to our sponsor, which is Reform Pharma, which is an initiative of Children's Health Defense. Thank you to the many viewers and listeners of this program. And each week I leave you with the following. That is, keep learning, keep challenging yourself, and always, always question authority. Have a good day, everyone.